Hello, I'm Jim Ward, and I am a lawyer. I've been a lawyer for almost 42 years, and part of my practice involves representing state health boards, and I have the privilege of representing what I call the O&P board. I find sometimes that saying orthotis and prosthetis correctly, quickly is a mouthful, so I'm going to refer today to the O&P board, and I hope everybody understands that. And also, it's somewhat misleading because other than orthotis and prosthetis, the board also licenses or regulates pet orthos, mastectomy fitters, and shoe fitters. Those of you who are watching, I appreciate it. I think this will be helpful. And let me tell you what my goals are. One is to try to inform you in the time permitted about what the law is that regulates what you do, how complaints are filed and how complaints are processed, and hopefully give you some pointers that will prevent a complaint being filed against you, or what to do if one is filed against you. The board members don't take great pleasure in having to have hearings to discipline people. So even if one of you watching can learn and not make an error, not make a mistake that would otherwise result in a complaint being filed, then that'll be good. All right, so let's begin by understanding that a regulatory board is created to protect the public health, safety, and welfare. Its mission is not to protect the licensee. And while at times the interests of the public and the interests of a licensee are the same, if there's a tension between the two, it errs on the side of the public. So try to remember that that's what the board members do. They regulate to protect the public health, safety, and welfare. In doing so, there's a law, and the law informs and obligates the board to do certain things. And simply stated, the two most important things they do are to make sure someone is qualified to get a license, and then once licensed, that someone follows the law and the rules that apply. There's a part of the law, and it's section 3425A, it's a capital letter A-6. Those are the grounds that allow the board to investigate and hold a hearing and then discipline. So the first thing that's important to understand is if a complaint is filed and it does not involve or implicate any of those grounds, then the board has no authority to act. So for example, if someone files a complaint that you did not have enough employees working for you, that is not something that is a violation of any law or rule. So the first thing the board looks at when it receives a complaint is to determine whether or not it fits within or could implicate any of the grounds that the legislature in passing this law says the board can be involved in. And I want to briefly go over each one so you have some idea of what they are and what they mean. And I am paraphrasing, I'm not repeating exactly what the law says, but I think you'll understand my meaning. The first is fraud in obtaining something. So for example, if when you apply for an initial license and you are asked questions and you do not tell the truth in those questions, in answering those questions, and a license or permit is issued, and it's later found out that you did not tell the truth, then that's grounds for a hearing before the board. Same if you renew There are certain questions asked on all renewals. If you do not answer truthfully questions on a renewal, then, and the board later finds it out, then that also can be grounds for a complaint being filed or for a hearing to be held. And I'm explaining a little bit about, I keep referring to a hearing being held, and I'm explaining what that means in just a minute. Next ground is gross immorality. And that would normally apply, for example, to what I more softly call boundary violations. That would mean, for example, inappropriately touching a patient, or talking sexually inappropriately to a patient, or to someone you work with. That is, under the law, is considered grossly immoral. And some acts can be considered grossly immoral. For example, if you are arrested for public lewdness, for using the restroom outside, everybody can see you. Those are things that the law considers grossly immoral. If you employ someone and let that person perform acts or job functions or duties or responsibilities that require a license, for example, a prosthetist assistant license or an orthotic assistance license, and the person is not licensed, then that is a violation. So be sure, very careful, to make sure that those folks who work for you, if you're going to be having them do job duties that require a license, that you make sure the person is licensed. And I would suggest that if, for example, you hire someone and they say, yes, I have a license from the board to be a prosthetist assistant, that you call the board office and check with Mr. Ronnie Ezel, our executive director, to make sure, or ask the person to give you something that shows that they have a current license. I represent other boards, and I've handled, I can't tell you how many cases, where folks in good faith believed that someone had a license, believed they were telling the truth, turned out they did not. So it takes a minute or two to call and find out. So please do that if you're hiring anybody, and make sure that once hired, the person only performs acts that the license allows them to perform. Okay? If conviction of a felony, and a felony is defined as where you can be sentenced to longer than a year and a day, that's what's considered a felony, or a misdemeanor involving moral turpitude. You spend a lot of time in law school learning about moral turpitude, and it simply stated, it's a moral wrong like stealing, shoplifting, or writing a bad check. Those are examples of misdemeanors that involve moral turpitude. Another ground is gross negligence. Negligence means that you have deviated from a standard of care. And if it has to be gross, gross means that it's got to be a little worse than just a innocent or mistaken a deviation. So for example, if you, let's say the standard of care is to always do A whenever you have a patient, and you continuously don't do A over and over and over again, that could be gross negligence because it's repeated over and over and over again. On the other hand, gross negligence could be something that happens one time. Let's say that your deviation was so bad that the person was badly hurt or injured. Then that could be that type of negligence that would make it gross. All right. If you violate a board rule or any part of the O&P Act, that's a ground for violation, a ground that the board can look at you and investigate. If any of you have licenses in other states and that other state takes an action against your license, then the board has the right to take an action against your license here, even if the act occurred in another state. And then the last one is what is euphemistically called billing irregularities. That's a polite way of saying insurance fraud. That is, you are filing something with the insurance company where you're claiming something that you performed that you didn't perform, or you claim you did work on a certain date and it wasn't performed on that date, or you claim that you did the work and someone else did the work. Those are all types of examples of billing irregularities. Okay, so who can complain? Who can file a complaint against you? Obviously, a patient can file a complaint. Another licensee can file a complaint. We've had I think one case now. Well, no, more than one case. We've had several cases where the complaint originated from another practitioner. A medical doctor could file a complaint, or the board can, in essence, file the complaint. You may be wondering, well, how can the board file a complaint? Well, remember I told you that if you don't tell the truth when you apply for a license or a renewal, and you get your license or you get your license renewed, then the board subsequently finds out somehow that you did not tell the truth, then the board would be the one who would, in essence, file that complaint. They would start the complaint. That's where the process would start. Right. The board has a complaint form that is required to be filled out. If you go online, I believe it's on the board's website, you can see the type of information that is asked for when someone does complain. If that is filled out in a proper manner and enough information is provided where it can be processed, then it's processed in the board's office, and Mr. Ezell assigns it to what's called a probable cause committee. Now this is very important. Probable cause doesn't mean guilt or innocent. It means, is there reasonable evidence, or is it reasonable to go forward to have a hearing for the board to determine whether or not someone is guilty or not. It's not like a grand jury, but it's kind of like a grand jury in the sense that there's an initial determination made about whether or not there's enough evidence to go forward with a hearing. Okay, who's the probable cause committee made up of? It's made up of 2 members of the board, Mr. Ezell and me. The members of the board who participate as the probable cause committee, if there's a decision made that there is probable cause, they do not participate any further. So the people who decided that there should be a hearing against you, who decided there should be charges brought against you, they are not involved in the actual hearing. They aren't at the hearing. They don't vote in the hearing, nor do they discuss it with anybody else until the case is over. So I don't want anybody to think that the people who are investigating them are the same people who are going to be hearing the case. That doesn't happen. The board, unfortunately, does not have an investigator, and unfortunately does not have a subpoena power. So when a complaint comes in, the board unfortunately is somewhat limited in obtaining the information that they need. If it's a patient complaint, or the complaint involves a patient, then the patient will sign a release for their records, whatever records are needed. The question always comes up, well, does HIPAA apply? Can I as a practitioner turn over my records of a patient without violating HIPAA? The answer is yes, you can. There is a clear exception in HIPAA that allows a regulatory board to obtain records without it being a HIPAA violation. So if it involves in any way something that happened at an office, then the records will be obtained. If there's some reason that the medical records from the referring doctor are needed, then those will be obtained as well. If witnesses are identified, then usually Mr. Ezell talks to the witnesses. And all this information is gathered, and then there is a meeting of the probable cause committee, and a decision is made whether or not there's enough to go forward to file charges. You may wonder, well, do I know if a complaint's been filed against me? And the answer is sometimes yes and sometimes no. If there are questions that the probable cause committee has, or if it's necessary, well, first of all, let me back up for a minute. Obviously, if it is a complaint about what happened in your office and the patient has signed a release for records, then you're going to know that there's an issue with you involving that patient. So you'll always know that. But if it's something that may not involve treatment of a patient, or involves the treatment of the patient, but maybe a billing issue, so where maybe you won't know about it because the release will be signed to obtain records from the insurance company, you may not know about it. Here's what you don't want to do if you realize there's a complaint filed against you. You do not want to modify or change your records. You don't want to at all do or say anything to where the patient who made the complaint or the person who made the complaint feels like you're threatening them or pressuring them. If you find out that another practitioner made the complaint, I would not be calling that other practitioner. If you haven't done anything wrong, then there's no need to contact anybody and try to get them to change their mind or change your records. If you feel like you have done something wrong, there may be an issue, what I suggest you do immediately is to contact a lawyer and get advice from a lawyer. Almost every case that I've ever had, I don't care what kind of case it is, I try cases with juries, I try cases before boards, I try cases before judges. Documentation and record keeping is important in every case. So I beg you, don't urge, I beg you to please keep good records. Make sure that your records are thorough and they're accurate. So that if there is a dispute about something, or somebody says that something didn't happen which really did, or vice versa, you have good records. If your records are bad and are not complete, then there is immediately a presumption, at least, that there's something wrong, there's something amiss. So documentation saves the day almost always. Now, maybe some of you may be thinking, well, if I've done something wrong, I'm not going to document it. Well, of course not. But if a patient says, for example, you did not explain a certain process to them, or says that you did not fully advise them of how long the process would take, or didn't fully advise them of possible consequences from fitting and appliance. Well, if you have good informed consents and good record keeping, you don't have to worry about that. Oftentimes, complaints are just a swearing match. That the witness is saying one thing and the practitioner may be saying something else. That's another good reason to have really good records. But in investigating the complaint, the board understands, the probable cause committee understands, that one person is saying one thing and one person is saying the other. So, for example, usually the complaining witness will be asked some questions to make sure that they don't have any bad motive for filing the complaint. And while that doesn't necessarily mean that the complaint is invalid, it certainly is important for the probable cause committee to know, for example, that this patient is the relative of someone who used to work for you that you fired. Or this patient is someone who you wrote a letter to saying you were going to take them to court because they haven't paid their bill. Obviously, those kind of things are looked at. I'm stopping and thinking because I'm out of time. I have time constraint here. I just have 30 minutes and I have no idea how long I've been talking, so I'm just, anybody, only 5 minutes? I've only been talking for 5 minutes?
No, I've been talking about 25 minutes.
Have I really?
Yeah.
Oh my God. Okay. All right. All right. All right. So, if the probable cause committee decides that there's no basis for the complaint, then you will receive a letter saying that the complaint was investigated and it was a determination made that there's no probable cause and the case is closed. That information is not a public record. So if someone asks the board, has there ever been any discipline against you? The answer would be no. That is not discipline, a closed complaint. If the probable cause is determined, then you will receive what's called a notice. And the notice will advise you of the time, date, and place for a hearing before the board. And it will outline the charges against you. If you receive a notice, then I suggest, if you don't already have hired a lawyer, that you hire a lawyer and you consult with a lawyer. And then the lawyer will explain to you what your rights are. And I'll tell you what they are. You have a right to a hearing before the board. The burden of proof is on the board to convince that there is enough evidence, that there's a preponderance of evidence. You have a right to cross-examine witnesses that the board calls. You have a right to call your own witnesses. You have a right to have an attorney. You have a right to some limited discovery, which is obtaining documents and finding out what the board's case is about. Lots of times cases get settled, get resolved, and it's very common for a case to be settled. Be settled by either the lawyers talking, or if the practitioner does not have a lawyer and wants to try to settle, it'll be settled that way. That's perfectly legal for cases to be settled, and if the case is settled, there'll be something called a consent order. That's what will get prepared. The consent order will be approved by the board. It'll be signed by the board's president if the president wasn't on the probable cause committee. If the president was, then the next highest officer. and signed by you, of course. That is a public document. That is called discipline. So if the board receives an inquiry, have you ever been disciplined before? The answer would be yes. If someone wants a copy of that, they are entitled to it. If there is a hearing, then it's of what's called of record. That means there's a court reporter there. Witnesses are sworn in, and they testify, and every word said is recorded, just like you see on TV, just like in a courtroom. The hearing is not conducted by the board. It's conducted by a hearing officer, or also known as an ALJ, Administrative Law Judge. That is a lawyer who presides. So he will rule, he or she, the board has two, one's a lady, one's a man. He or she will rule on any questions that come up during the hearing. If a lawyer objects, then the hearing officer will rule. If there are pre-hearing matters that are conducted, and it's necessary for the hearing officer to make any sort of decision, they will do so. After all the evidence is presented, then the board decides the case. I don't go back in there with the board. Mr. Ezel is not involved in that. The licensee is not involved, or the lawyer for the licensee, nor the hearing officer. That is, the board is the jury, and the board by themselves decide the case. And they decide two things. Number one, were the charges proven? And if they were, what kind of sanctions should be imposed? The law allows sanctions of the highest, most harsh type, which is a revocation, all the way down to the most mild one, a censure or a reprimand. The board can impose a fine, or they can impose limitations on practice, or they can put you on probation. It just depends on what kind of case it is. If you have an order entered against you, either by a consent order or by a final order, and the final order is when there's a hearing before the board, and that one is called the final order. You have a right to appeal if you don't like the way the board ruled. And there's a very precise way to appeal, and appeals are what are called jurisdictional, which means there's certain times in which you have to do something. And if you are a day late in doing it, then you lose your right to appeal. So if you have the misfortune of having an order decided against you, a case decided against you, and a final order is entered, you certainly need to talk to a lawyer if you want to appeal for the proper way to do that. And the appeal is to the circuit court, and the circuit court judge then decides whether or not the board was correct or not in what it did. One last thing I want to mention is cases where people do things that don't have a license. What can the board do? For example, if someone is practicing orthotics or prosthetics and they don't have a license, well, the board can't sanction a license. They don't have a license. So what the board will do and has done is they'll file a lawsuit in the circuit court where the acts are occurring and ask a court to enjoin. Enjoin is a fancy legal word meaning stop the person from doing what they're doing until they have a license. Proceedings before the board are not criminal, and they aren't civil. They are administrative. So, and that's because they have parts of both. For example, the rules of evidence in a hearing before the board are the same that are used in a civil case where a judge is sitting without a jury. But you have certain rights which you don't have in a civil case. For example, the right to a lawyer, which you do not have in a civil case. So it's a little of both. So it's really not civil, it's really not criminal. It is actually an administrative due process, administrative proceeding. That's what it's called. One last thing I want to say is this. Most of the time in life, and any of those of you who are parents, either of small children or even if your children are grown, know that oftentimes folks ask for forgiveness rather than permission. They go ahead and do something wrong and then go, "Oh, I'm sorry, please forgive me." And while that works most of the time in lots of ways, when it comes to your permit, when it comes to your license, that is a foolish, imprudent, not smart adage to follow. You should ask for permission first. If you're unsure about something, if you're unsure that whether or not an action you want to take is a violation, take the time, please, to call the board office and get the answer. If Mr. Ezel doesn't know the answer, he'll confer with the board member, and if it's something that may involve a legal matter, they'll get me involved. But please do that, because what we see is a lot of the times when the complaint is filed and a licensee is facing a discipline, if they would have taken the time to make a phone call or ask a question, it never would have happened. Thank you very much.